Welcome, everybody, to Justice Serve Daily. I hope you're all doing well today and have had a good day, and I hope you're living somewhere that is very, very warm. And I want to go ahead and do an update on some information for Delphi and a few questions that we commonly get. So I want to just go over to that really quick here. And I'm going to have to do that by sharing my screen. So let's see here. One day I'll be as fast as all those other people, but not yet. Not quite yet. Okay. So, as you may have seen by the title, we've got the state of Indiana response to the petition filed for Richard Allen, to allow Richard Allen bail and release because he believes that he should have that, believe it or not. So let's go listen to, I say listen because I never know what my computer wants to do. And I want to show hopefully. Did you miss me? Sorry, guys. Wow. I could have done like a whole show and not realized I wasn't on the show. There you go. Okay. Well, that's why I'm glad I just checked because I was going to take it out of that info. Show. Entire screen. Allow. I'm so sorry. Okay. And now I'm going to pop this back up here. All right. Sorry. We're going to skip his face again. There we go. So, as we know, in the probable cause affidavit that was released was only the release of charges. They didn't have to put every bit of information on there, every bit of evidence that they have on there, but that would have Richard Allen arrested. But we do not have the probable cause yet of the search warrant that went on his house. So right now I am showing on the screen, again, for people who like to go look for this stuff yourself, it's not really that hard, honestly. But I like spending time with you, so if you don't want to and you just want to come look, if you go to mycase.in.gov, you can look up cases in Indiana, and you can see this is Richard Allen's case and information, pending info, all that kind of great stuff. And just like I showed you guys before for, I almost called him Anthony Schatz, right? Keegan Klein, his page and how long and stuff that page goes, just showing all the charges and stuff for it. So what we see right now, as you can tell, that there's an update in the response to the petition filed, which is just what the news and stuff is getting right now out there about that just happened yesterday. And that the response is basically saying, we have enough evidence. We don't think you should have bail. You shouldn't be released to wait for trial, any of that type of stuff. So the jury trial information, though, you can see ahead of anything that's scheduled when you go to my case and check it out. So the session, you can see what has been canceled for dates and what is coming up for him. So, obviously, we're all waiting for the date of February 17th coming up for this bail hearing. And I've had a lot of people who have asked, okay, well, wait a minute, what's the law in the state of Indiana? And we've covered this before when we talked about the murder case itself, and back when the defense attorneys were actually asking for him to have a bail hearing. And we're like, lots of people are like, okay, why is there a bail hearing? What are the laws in the state of Indiana? What does this all mean? So I brought back up on here for you, just like we did before, and talking about what the Indiana code is, and try to just highlight specific information about bail bond and how it's defined in Indiana. So obviously, just like any place, that bond is executed by a person who has been arrested for, some type of offense. And then what is the purpose of bond? Well, we know there's main two purposes that the bond or bail is going to be put into effect. One, it's to make sure that that person shows up to trial, right? They have to, we want them there. That's the purpose of having that. The other one, though, is of public safety. And that is what has to be considered when anybody, when the judge or anybody is looking at putting this, as well as the prosecutor. Should he allow it? How high should it be? That type of thing. So as we go over, and I'm just kind of popping in here only on the pieces that relate to what we're talking about, is the offense of murder and what it means in the state of Indiana as far as bail is concerned. And so plain and simply, murder is not, I hope I said this right, murder is not bailable. Does that sound right? Yeah. You don't get bail if you commit murder, right? If there's proof that the proof is evident and the presumption is strong, right, that this person committed the murder. So that's why when this all first happened, and, we have the defense attorneys that when they got a sign and they're coming out there and they're working with them, and immediately they're out there talking to press, right, before we had the gag order put in place, like December 2nd, like not soon after this happened. In my opinion, I believe that the reason that they were doing that is because also immediately they were out there just saying, oh, this evidence doesn't mean anything. Remember October 31st when we heard that he was arrested, and we had that announcement done, and they were not releasing yet the probable cause affidavit for arrest or for the search warrant, again, which has not been released. That's the reason that I believe, in my opinion, that the defense attorneys were out there talking right away, because that's their job, right? If you hire them and they're trying to do what they can for you, they're going to try to go out there and tell people that, it's wrong, it's not true, what's being shared, not all the evidence is out there, the evidence doesn't add to anything. Again, we don't know all of the evidence. Not all of the evidence has to be put in the probable cause affidavit for the arrest. They will eventually, yes, have to share. Prosecutors have to share all the evidence they have against the defendant, because then the defense attorneys have to fight that information, right? But anything that the defense attorneys get, they do not have to provide to the prosecutor, right? So, and I know in many of our true crime cases that we have watched trials or anything for, we know how that goes. So again, this is one that is not bailable if the proof is there, if the proof is strong. So what was happening? The request goes in of like, hey, we need a bail hearing. We need to talk about, him possibly being released while he waits for trial. And then the next things that are coming out and being shared is, that's not enough evidence. This probable cause affidavit of what's not redacted that the public can read. Hey, look at this, guys. That's not enough stuff. They haven't proved that evidence isn't strong. He should be let out. So then the next question I know I hear, and I know a lot of you hear, is, so why are they even allowing this hearing if in Indiana the law is that murder is not bailable? Why does that sound so weird to me? Bailable. Well, the reason that is because I'm sure, again, I'm not an attorney, nor do I play one on TV or YouTube. But the reason is that I believe is because all these cases that we hear of something that can happen that is not allowed, that suddenly allows a mistrial, right? So let's say that maybe if the defense attorneys come back and say, you know what, we want bail, and then they say no, or they didn't even ask for bail, then that could be something they come back and say, well, I was misrepresented. My attorney never asked for a bail hearing, and so on and so forth. That doesn't mean that you can claim a mistrial because you're not granted bail, But I'm sure that if you can sit here and say, hey, my attorney never even asked that I could be released on bail, then that could be a reason. So for that reason alone, I feel like it's a good reason for them to be able to allow it to be heard. So, and again, here it says a person charged with murder has the burden of proof that he should be admitted bail. So it's on them to prove. And again, remember, I don't think it's because we're trying to make sure he shows up for court, although that could be. You could try to disappear if that's the charge, right? But I mean, come on, isn't public safety like the big one? What's being accused here, right? So I included this next bit of information in here. Now, I did not because of the fact that Richard Allen has not been charged with any sexual assault, sexual violence, anything like that whatsoever. But I just, let's put it as an FYI. I'm just going to put that as an FYI. Because remember, his two charges are murder, are kidnapping, and that murder happened during this, right? So he doesn't have to prove murder. He has to prove they have to prove kidnapping based on the information that we've reviewed before on the charges. But bail procedures for a sexually violent predator and defendant. It applies only to a sexually violent predator or defendant. And then it shows and defines what that means. You know, this person is a sexually violent predator, and what that defines is arrested for or charged with commission of an offense that would classify that person as a sex or violent offender. A court may not admit a sexually violent predator defendant, person charged with child molestation, person charged with child solicitation, to bail until the court has conducted a bail hearing in open court, except as provided in Section 6 of this chapter. The court shall conduct a bail hearing not later than 48 hours after that person has been arrested, unless, and then they talk about the circumstances that prevent the hearing from actually being held within those first 48 hours. So there's more restrictions and stuff on there. And, you know, that's another thing to look at as far as timing. So when you get arrested and then the probable cause is released, they have so many days, depending on your charges, of how soon your court case is supposed to be heard, how soon your bail case is supposed to be heard, so on and so forth. So it's different for each one of those in there. So the next piece that I went ahead and kept it in here, and it just talks about, you know, an amount of bail and facts taken into account about that. So, and this is my dog who likes to bark only when I'm on the phone or on YouTube. I have 2 dogs, but he's the one who likes to bark. Oh, maybe he's calmed down a moment. Okay. So that talks about facts and taken into account by clear and convincing evidence that the defendant poses a risk to the physical safety of another person or the community. In setting and accepting an amount of bail, the judicial officer shall take into account all facts relevant to the risk of non-appearance, including, and then it talks about that person's stance in the community, right? Their employment status, their family ties, their character and reputation, the defendant's criminal, or listen to this, or juvenile record, right? Is that a little shocking? I didn't think so. I thought so, but at first, So that they're able to consider when they're looking at trying to have this bail amount actually set and stuff too. There I go. Can you see me? There I am. But this information, again, I wanted to be able to share because I know that it's just common questions that keep going on. Why is he even being allowed the bail hearing if Indiana doesn't give it? Why are they listening to it? Why are they going? What's interesting is that we're able to see and use information that they've shown before, and it is curious because you're like, boy, I would love to see more of the info. I know what the defensive team wants to see is that they want to see what let them go into the house, right? What was it that let them have the search warrant initially? There's a lot of stuff going on about that, a lot of stuff of what could have allowed them to go into the door, right? So we've all heard it all. Is it somebody's flipping through old papers and said, oh, wow, he talked to somebody else before and nobody else talked about it. So boom, that was it. Was his name dropped maybe by somebody else? Was it just a coincidence that it happened at the same time after the river searches were done and that, um, Keegan Klein was moved out of his jail cell to go into the same county and talk about, things, and suddenly he's released, and then a couple of weeks later, or he's released back, the search is over after about 5.5 weeks, and then suddenly, you know, it's not related. I will say that for me, that is a lot of information that is I can't ignore. I will say I'm going to admit my total bias of that because I just don't think that we can ignore the Keegan Klein connection of the Anthony Schatz profile and what he admits to. So um, that is, I think, very pertinent information that you can't ignore, saying, oh, Anthony Schatz also says, hey, I went to meet her. Now, am I saying that conversation and the Anthony Schatz reply would have been just could have just only been Keegan Klein? Absolutely not. Because he could have, as we've gone through information, he absolutely shared that he gave that Anthony Schatz profile actually to more than one person, because I've now heard that on a different news channel that talked about that he had shared it to more than one person, which is interesting because even just one person makes it harder for them to prove, right? That's what the hard part to prove is. You know, for example, in speculation and total big time speculation, let's say, for example, the person he gave this to is his father. And if his father has it, well, if you have two people in the same house and you're using the same devices logged in the same bias named person, and you have the same people using the same Wi-Fi, internet, IP address, right? If you have the same people doing this, how can you tell which one versus the other? Other than we do know that the officers were saying in the interview with Keegan, hey, this sounds like two different people talking, because you can tell if it's a different person or the same person you're talking to, right? So, I just find it interesting. Now, what's our next leap to think here? Our next leap is, do we believe that on February 17th, which is 16 days away, that Richard Allen is actually going to be allowed to have bail and to be released? Now we know Indiana law. You're not supposed to be released, right? We just looked it over. You're not supposed to be released for murder charges if the preponderance of the evidence proves that you did it. It is the defendant's job to show and prove that they should be allowed bail. Do we believe that he is going to be let out of jail to wait for trial after his accusations are that he's been accused, yes, innocent to proven guilty, absolutely, absolutely. But I have a hard time believing he's going to get out of jail for those charges when we know that we've got Keegan Kline in jail since 2020 for CSAM. And CSAM is horrible. It's abusive. It's horrific. It obviously, possibly, and could have led to the death of um, and led to the death of these two girls, of Libby and Abby, right? And then, but you're talking about this is the person they're saying, because we believe we see you. The accusation is, we believe we see you on the bridge. We believe that we hear you tell those girls to go down the hill, and then we don't see you again, and we don't see the girls again, and the next time that they're found, they're passed away. Do you guys believe out there that it's going to be possible? I don't. I don't think he's going to be released. I think they're going to the formality of it so that there cannot be anything said that they did not give him the opportunity to possibly speak his case, and that he can't go back on it. How does chat feel? What are your guys' thoughts? All right, I see no bail, and I'm trusted also to catch up with any questions. And by the way, hello everybody. Thank you for joining. I see a bunch of you who've joined in. Remember, I can never figure out how to watch my chat while I'm in the PowerPoint or showing videos, or AKA not showing videos, right? I don't know what that problem is. Yeah, I don't think, honestly, I don't think it would even be safe on his behalf to be out on bail. I didn't believe Ashley Garth would be let out, and then she was. So now I have to say it's possible. Oh no, cold truth. It would be horrible. Yeah, it is. I mean, the case is now is horrible, but that is true. Cold truth, I'll have to have you come over and share some of your cases. And there is a lot of good creators in here right now, that I see I never want to miss anybody. Cold Truth has a great channel. You should go check her out. And Evil CJ. Hello, Mr. CJ. Kid Kitty. Hi, guys. Grizz. Kelt, Mama Bear, Paige. Yeah, I'm not, it is, it's like biting nails. We go from like a lot of information down to nothing, and then a lot of information. I will tell you, my theory, my opinion and stuff is, and there's two, is that, before Richard Allen got these defense attorneys, my thought process was, if it was because somebody turned him in or knew that he's part of it or whatever, that maybe Richard Allen would have walked in there and been like, okay, you know what, I'm willing to take a plea deal because we do have the death penalty in the state of Indiana, and um, we'll take that off the table if you confess. But he has a very strong defense team that has come in and who has worked other cases. And one of them that I know is worrying a lot of people is that the defense team, one of the defense attorneys, has worked a case where a person who was charged with 3 murders actually had their search warrant thrown out. And it was for some type of, thing that he just pointed out to the courts. And what is the fear of that? They're wanting that probable cause for the search warrant on Richard Allen's house released because they want to find something wrong with it. And what happens if they do? Then you have to look at what evidence would be thrown out that they found there if they have to throw out the actual search warrant. And guess what that would be? What is one of the main things that everybody even keeps questioning about? It's the bullet. It's the gun. So if that would happen, then what other items could we not hear about? Because we don't know all the information yet, and we don't know what's all done, right? They could be doing electronic forensics on computers, on cell phones, on everything, that whatever reason made them go knock on that door, start the search warrant. We don't know for sure. We hear this, that, and the other, but we don't know for sure. The other piece of evidence that the search warrant's all good, that I think could not be denied, and is the car, right? And this is why I say that. Again, in my opinion, total speculation. Not authorized in all states of the United States. I don't know. Whatever I legally have to say. Speculation. If the car that he did not get rid of is a car that was seen and that was used to get inside of after the murders were committed, and if he is a person who is walking down the street that this driver sees, muddy and bloody, right, described as muddy and bloody, and gets into a car to drive away, what are they doing to that car? Well, welcome all true crime people. We know what they're doing. It's called the spray. They're looking for the spray of any type of blood evidence. And if you have followed any type of case like that, it doesn't matter how much they spray that vehicle down. Or, I'm sorry, he washed that vehicle down. That when they spray it, they can still find the very smallest evidence of the blood. And when they do, absolutely, White Wolf. It's called DNA. And once they spray it, they pull up the DNA, and if there is DNA from blood that is from either one of those girls, and I would argue the fact it would have to be both, right? Because, just because we know how the scene has been described, there's no explanation for that. You don't have an explanation for that in the car. So that's pretty important. That's pretty important information that we don't want thrown out if there's something wrong with a probable cause affidavit to search his home. And those are the items that we know of, right? The gun, the bullet, the car that was taken away. Who knows what else could be in there? I mean, there has been all kinds of speculation of what else could have been in the, boxes that were removed. Lots of people talk about, okay, they removed maybe a jacket, they removed some other stuff. But here's the thing: if you have a jacket, you could easily go purchase another jacket just like it, and more than likely nobody's going to pay attention, right? You go buy the same type of jacket you had before, nobody's going to notice, and you could check, and there's not going to be anything on it. You could do the same thing with boots, right? Supposedly, maybe boots, speculation. If boots were taken, he could have went out. Anybody could go out, buy another pair of boots. There'd be no evidence and stuff on the boots, and be like, oh, well, wait a minute. We thought these are the boots you think that he was in. Well, nope, there's nothing on it. But you can't explain the car. So I really hope that there is solid information that can stay in there, that can remain what it is. And I hope that, and here's the question I don't have, which, well, I guess have to all figure out, and that I will be trying to figure out and share with you when I do, is in the information that the attorneys provide, can they now add to that probable cause affidavit, right? For example, let's say now they discovered something else. There's something else that they found, or something else, electronic forensics, there's something DNA, there's something somewhere else on any of it. Can they now add that to the bail? I know they can add it to the end of till the trial happens, but can they add that to why he should not have bail? And that would be interesting. Chris is asking, okay, I'm sorry, starting to look at chart. I'm still wondering why he supposedly had his wife's car. You know what? I just think that you know what, you're going to do less vehicles as you can possibly be noticed in. But then does that help explain a possible purple PT Cruiser? I mean, come on, people. You drive a purple car, really? White Wolf, he's an idiot for keeping that car and his clothes. He's done. They will have all of the DNA they need, and he should not be released on bail, especially if they already have DNA evidence. Exactly. I have been wondering though about the DNA evidence for a very long time, because I don't feel like this case should take 6 years if you had DNA of somebody, right? And it's going to get me started, so forgive me for this, but I can't let go the fact, regardless, that if he came forward to say, I was there at these times, I was on the bridge, trying to remember all the excuses. I was looking at fish 80 feet up in the air. I sat on a bench. Oh yeah, these teenage girls who possibly saw me, that I know is probably gonna say they saw me. I saw them too. Yep, I saw them, but I didn't see anybody else. It's and then to not catch up with him until now is mind blowing to me. And isn't that the case though with so many true crime cases, especially when you go watch anything that's like old cold cases, and then you're like, oh my God, they knew for the longest time like who it was in some of these cases. And then, sometimes something can be overlooked, right? Or, you know, and I'm not saying that, yes, of course, if he's not committed a crime, he hasn't been in jail, then they don't have his DNA. Get that. He lived 5 minutes a walk away from where the scene of the crime is. I'm sorry, he worked 5 minutes away. He probably lived, right, less than 10 minutes away from it. So when you're sitting here and the car by the CPS building we've been hearing about forever, the CPS building, right? The very beginning, we heard a car. If you can identify, if you were in the car, please tell us if you were parked up against the CPS building. Never told anybody a color, never told anybody a type of car, never told us any of that stuff. And so everybody was wondering, okay, was that something or was it not? Just like they said, hey, if you were walking across the bridge and you were this person, hey, give us a call. Well, obviously, if that person was him and he never called back and said, hey, guys, that was me, right? He never identified himself. But if he never had the DNA, wouldn't you start doing a search within, I don't know, starting within the first 10 to 20-mile radius surrounding the crime scene of anybody who's driving those particular cars that you may possibly have seen? I mean, you're going to narrow down a community. If just to check in the community, you're going to narrow down 3,000 people who live there. You're going to narrow them down by, okay, description, white guy, about the age range, right? In the area, possibly driving this, and this vehicle. So, I'm sorry, am I glitching? Oh, okay. People are hearing. I'm sorry. Sometimes I can glitch on my own or just by the just by my microphone. So, I mean, it's just frustrating to me that even if you don't have DNA, the first searches would have started within that community and then started going outward. And he was so close, and so close. It's scary. It is so scary. To be there in Delphi and to think that, there was such a search going everywhere. Those FBI photos and I mean, it was going everywhere, thinking, oh, this guy could have come into town and used to live here and used to work here and used to do that. Guess what, guys? He did both. He still did both. So, this was not a, long particular video and stuff in here, but I don't predict that Richard Allen is going to get bond, my opinion. He's not going to get bail. I don't think he's going to be let out. I think this crime is too serious for that to happen. And I do have to say that obviously, if something happens, there'll be so many true crime shows on saying, oh my God, he got bail. that I don't even know if you guys could even keep up with them. Maybe all the Delphi shows should combine and be on live together because we'd all be in shock. It's crazy. So I think that covers at least what we have right now, what was released in the news, what we see at least on his file. I definitely also feel, because I've also seen and kind of heard that his trial is not going to happen as soon as they have it in there, by the way. The one that, that we just sat here and looked at, that, is trying to say, that he's going to sit here and possibly have trial dates. I just don't see it happening that soon. Look how long we waited for Keegan Kline, and that's not on a murder trial. Because the sessions originally were supposed to be scheduled for March. So he would have had March trials. There's no way. Right, White Wolf. Well, not only, the other reason I think bail, it's supposed to be for community safety, right? It's supposed to make sure he shows up. But to be honest with you, why would he want bail? We've heard about in info that you hear about that threats and stuff that they have him in. He's in a secluded area because he hears threats and stuff from people about hurting him and stuff like that where he is. Why would he want to be out in the general public where, honestly, somebody who's not, take it upon themselves, another crazy person and taking something in their own hands and trying to go after him or anything like that, right? And not let a trial convict him and not let justice be served. And then, he would be in danger. They're not going to provide him security at home. Sorry, I'm reading chat. Have one. Does Keg have one set? Cold Truth, do you mean one set of defense attorney? I think that right now, the only one I know of is about, he had one individual person that was for CSAM. And now I have my theory again about what I think could happen too, because I feel like if you guys haven't watched the show, I did an updated show that showed the request for public information record that I did for Miami County Sheriff's Department, asking for the updated visitors log for Keegan Kline. And as you know, the murder sheet was able to get the early part of the year copy of that when he was still facing CSAM charges. And with all what, we didn't have all the details and information about that. Well, suddenly the end of the year of 2022 was blocked and not being able to be provided. And I did share with everybody about the reasons that they used, which was basically about criminal information, about criminal stuff that he made. There's charges that could be charged to him, and so that's why it could not be shared of his visitors and what's going on. So my understanding, my thought process on this is that it's not being shared because I believe, in my opinion, they're not going to be all of a sudden hiding from public information about a CSAM. They're already negotiating stuff down. They've already dropped charges. They've already lowered charges, right? They've already done all that stuff to him. So why would they now block what's going on? Well, let's think about that for a minute. During this time frame, during the October, right? During the September, October time frame, he was being moved. the water searches for Wabash River were happening, right? And in between that and beforehand, other people are talking to him. And people stated that the news also stated that the Wabash River search did have to do with the Delphi case. So if they do have to do with the Delphi case, and that's the search, and what is the gag order on? The gag order is on the Delphi case, not on the CSAM case, not on Keegan Kline. Keegan Kline has not been charged with anything with the Delphi murders. However, if he is cooperating somehow, if he does have some type of knowledge and he is cooperating with that, and if he was part of this speculation, right? He is part of the Wabash River. If he was speaking to Doug Carter when Doug Carter flew in, when he was switched in the systems, then that would be closed up, wouldn't it? Why? What speculation? Why? Well, remember, they think somebody else could be involved. So would they let that somebody else think that Keegan Kline is cooperating? Probably not. So what else? What other reason would those records be closed? What other reason would they not share what the visitors are in the visitation, right? It could be the prosecutors. It could be Doug Carter. It could be all of the information there that's leading into that. And I mean, my speculation is that I think later on that when it's finally all said and done, Keegan Kline could probably come out and they could say, oh, we already have a deal with Keegan Kline and so is now being arrested. Speculation. Oh, I'm sorry if I'm cutting in or out. I move a lot when I talk. That could be it too. So terrible. I'm sorry, SRB. Oh, it was you. Usually it's me. It's okay, RCB. That's my opinion. That's what I think is going on with this. I have not heard anything else, on bond or anything for Keegan, but I do think that this information and this deal was happening for two reasons with Keegan. Again, in my opinion, speculation. One, we will lower your CSAM. We will lower your charges for this. And two, you will also not get the death penalty. You will also not get full charges for this. And then there you go. Because I honestly don't think that they could use just Richard Allen's comments, for example, that somebody participated in it, not that he's saying anything, or even just Keegan Kline's, because my God, it's pretty easy to prove that Keegan Kline is a liar. So anyway, I appreciate all of you joining here tonight for this true crime quickie, right? I'm glad all of you are able to join us. If you have not seen about the document that I requested, go look in the previous show. It'll talk about that document. I show you in it in the show of that information about the trial, staying in Carroll County, but talking about how the jurors are coming out of Allen County, which is where that actual judge is from, which is the Fort Wayne, Indiana area. And yeah, go watch back with Keegan Kline, what was found on Keegan Kline's phones, the affidavits, the police interviews, all those types of things are all in here in the previous shows. I appreciate you joining us. Please hit that like button. Please hit subscribe. That helps out. I am not a monetized channel by any means, but I do feel the love when you subscribe to me. And I appreciate everybody being out here. And I appreciate you being one of the justice warriors, and I appreciate you being here to make sure that justice is served daily. Good night, everyone.